the where their robes are.
All rise. The Honorables, the presiding chief judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. Welcome to your North Carolina Court of Appeals. I'm Chris Still, and I'll be presiding today. To my right is Judge Valerie Zachary. To my left is Judge Chris Freeman. I'd like to thank our clerk today, Roderick McFarland, and thank you for Tom Salou, who's our marshal today. We have one case on the calendar. It's State versus Williamson, and I believe it's a 30-minute argument for each side. So we'll hear from the appellant. Let me know if you want to reserve any time for rebuttal.
Yes, Your Honor, 5 minutes.
Okay, perfect. You may begin.
All right. Good afternoon. May it please the court. My name is Cooper Strickland, and I represent Mr. Williamson. Mr. Williamson's conviction based on the admission of indictments and judgments of co-defendants who did not testify at trial should be reversed. The parties agree that guilty pleas and convictions of non-testifying co-defendants are inadmissible unless introduced for a legitimate purpose. A legitimate purpose is something other than evidence of guilt. Our courts identify this principle as a, quote, clear rule. Here the state concedes at page 28 of its brief that, quote, it appears that the evidence of the criminal judgments and indictments against Mr. Conrad and Mr. Fawcett were used for no other purpose than as evidence of guilt of the defendant.
What's our standard review on that? Because is it plain error?
Well,
at least on that piece of it. I know you have an IAC claim and those kinds of, but just on this, was it properly objected to or not?
I believe, as we've said in the briefing, the transcript is not as clear as the appellant would like, but I think arguably an objection was made. I can walk through that if the way I analyze that, if you'd like, but I do think arguably an objection was made.
I'd like for you to go through it, please.
Okay. First, I'd like to back up then and just put a little context out there regarding the relevant procedural history. The state provided pretrial notices it was required to under statute that it did not intend to call Mr. Conrad or Mr. Fawcett as witnesses. Rather, as described at 256 of the transcript, the state elected to rely on the testimony of the clerk's office staff member to establish a conspiracy by having the individual read the indictments and judgments of the non-testifying co-defendants to the jury. The state's pretrial decision to rely on inadmissible evidence without meaningful notice likely complicated trial counsel's contemporaneous response to the state's introduction of this evidence. Now, that initial context, the lack of notice that these actual co-conspirators were going to testify, in all honesty, would throw me off. And whenever you go directly to the transcript where this occurred, it begins at page 251 when the clerk's office staff member takes the stand. I think you have some initial issues right out of the gate regarding the foundation. I think there was a lot of focus on reliability and not much on relevance before the exhibits were admitted. And just, again, so there's an identification of the exhibit number, 11 and 12, referred to as, quote, indictment and judgment. And then the next question is, what seals do they bear? The seals of Durham County. And then the state immediately moves to admit those documents as self-authenticating documents. And the defense counsel says no objection. I think in all likelihood there was a little bit of jumping the gun, but as far as the guidance in the case law on Rule 10 that's stated in the appellant's opening brief, it says usually apt time to object is when the question calling for inadmissible evidence is asked. Where the admissibility of evidence becomes apparent only upon answer, the proper objection is a motion to strike. So I think there's two ways to skin that cat. But I would like to dive a little bit deeper in what happened with the transcript. So you have the initial admission of the indictment and judgment for Mr. Conrad. Then you go forward and the state specifically asks the clerk's office member, what is a judgment? There's an objection from defense counsel. Then you run through this progression of the name. Mr. Conrad is then provided. The date of the offense, July 22nd. These are facts that you're beginning to understand what maybe this is relevant to. And then you have an objection from defense counsel again on relevance and hearsay. Now again, it's a little bit muddled, but I think that those are enough, particularly when you're dealing with a clear rule, to put the court on notice of what was going on. After that objection was denied, then you have further detail provided through the questioning of the address of the property, the subject property. Then you have a description of the property stolen, a dryer, and then the property owners, David Glines. Now, I think, again, there was probably a little bit of a jumping of the gun by defense counsel in not objecting. But with what was laid out in the pretrial disclosures regarding witnesses and really just authentication of the exhibits, I think that counsel eventually got there. And I think under these circumstances, again, where there's a clear rule, the trial court was on enough notice of what was going on. And I think even some of the cases that the state has provided in its initial authorities kind of shows what a trial court would typically do, which is keep that evidence out and then provide a curative instruction.
Do you think the objection made was based on what at trial?
Relevance and hearsay.
It's relevant. I mean, the indictment says the three of us worked together. That's relevant. Whether it's competent is different. Me testifying that Judge Zachary told me something happened is relevant to the murder if she tells me. It might not be admissible, but it is relevant.
Right, and this isn't a hill I'm going to die on as far as whether the objection was proper or not, but I do think arguably it could be.
So can I ask you there, you said that the objection was to relevance and hearsay, is that right?
Yes.
So are you conceding that the indictments and judgments of the co-defendants Fawcett and Conrad were not objected to based on the confrontation clause or the clear rule?
Well, I think that a hearsay objection necessarily implicates a confrontation clause issue, and relevance, with all due respect, I think in this context would be that you have to have a trial based on the evidence that's applicable to this defendant, not non-testimonial evidence from co-conspirators who aren't even on the stand.
But isn't hearsay only one segment of a confrontation clause objection? And so how does this give notice to the trial court?
Well, again, I think it's messy. Again, that's not something that I'm denying. But again, when you have a clear rule, I think that the trial court probably had enough notice that you couldn't do this. I mean, for example, if a defendant came in and tried to put in some kind of a judgment of acquittal, that would probably be picked up on right away. So I think it goes both ways.
So if you're saying it was objected to on relevance and hearsay, my question, I guess, is how does that objection preserve this argument under our rules here?
Well, again, it's within the context of a clear rule that you should not be putting indictments of individuals who are not even testifying before the jury, particularly whenever the defense counsel did nothing to elicit this. It wasn't brought out on cross-examination and trying to bolster the credibility of the state's witness or anything like this. This was a conscious choice to come into this trial and use a clerk's office staff member to read indictments and judgments to the jury in order to get a conviction. And, you know, the state, in defense to that relevancy and hearsay objection, made pretty clear that they needed this evidence in order to establish the conspiracy. And that's true. I think when you look at the record as a whole, this is all they had.
So what's your argument on plain error?
All right. I believe that the parties appear to agree that a fundamental error occurred at trial. I mean, this is somewhat repetitive, but in short, a clear rule of evidence was violated, as were Mr. Williamson's due process and confrontation rights. The error was also highly prejudicial and had a
But I'm going to interrupt you here. You said his due process rights were violated at trial?
Yes, because this implicates
But because of confrontation clause, because the defense attorney said hearsay. Am I understanding your argument?
Yes,
again, hearsay leads to due process and confrontation clause.
Well, I think relevancy would too. I know that it's not perfect, but my argument is it's close enough.
Okay, thank you.
So, just continuing on with the impact on the outcome. The indictments and judgments of non-testifying co-defendants and Mr. Williamson's fingerprints were the only evidence connecting him personally to the alleged crime. In fact, at page 256 of the transcript, the state responds to trial counsel's relevancy objection by stating, quote, "The fact that there are convictions and fingerprints for both Mr. Conrad and Mr. Fawcett from that day do indicate evidence in furtherance of the conspiracy. Absent the reliance on this inadmissible evidence, which was the only evidence of a conspiracy, it is significantly more likely than not that a different verdict would have been reached." And then finally, the error also seriously affects the fairness, integrity, or public reputation of judicial proceedings.
What was the evidence, aside from the indictment? The indictment contains basically a statement saying that a grand jury found these three people worked together to steal this object. That's what the indictment said. And you're saying that shouldn't have come in. So the only other evidence was his fingerprints were not inside the property, it was just on the dryer or whatever. Is that right?
Yes, and this is described and set out in the opening brief. None of these three individuals' fingerprints were identified inside the home. The two co-conspirators who did not testify, their fingerprints were found on the exterior of the home, and one of those individuals had fingerprints on the dryer. Mr. Williamson's fingerprints were only located on the dryer.
Yeah.
So this is a very tenuous connection. Again, you have a dryer that is sitting outside in an unsecured yard for 2 hours before the crime scene investigation was done. It's pretty clear from the body cam video that the officers both went into the residence, and there were periods of time when you cannot see the outside of the home or the dryer. And then when they exit, just before the footage ends, there is an unidentified individual just walking away from the scene of the dryer. And I think there's also extensive testimony in the record from the state's witnesses, the police officers. This was a high crime area, vagrancy, all kinds of issues. That raises a lot of questions, particularly on this third element of plain error about the fairness and integrity of this, is that this would result in a conviction. This is pretty thin.
But isn't circumstantial evidence allowed? The state can rely on that to prove its claim, can it?
Absolutely. I mean, circumstantial evidence is just as good as any other. So.
And so, isn't that what this is? The fingerprints on the dryer?
Yes, but the case law on this issue, you can't just have fingerprints. Otherwise, probably everybody in this room would have stolen a dryer at some point. You have to have more to show that those fingerprints were imprinted at the time of the crime. And without the indictments and judgments, I don't believe you have that in this record. Just to continue on that point about the reputation of the judicial proceeding, the verdict against Mr. Williamson was reached without eyewitness identification of the perpetrators. I think that's another critical point. You have one witness that night who testified. He was in a joining unit of the duplex. He did not see anyone from the standpoint of being able to personally identify them. He saw individuals in his yard, and he had heard them prior to their exit. So that's really complicated. No officer arrested any individual at the scene, nothing that you would see that would kind of bolster the connection here. And again, the conviction was based solely on fingerprints evidence identified on an appliance that had been removed from an active construction site. Construction had been going on this duplex for nearly a year. In fact, the witness who was there, the son of the property owner, he was there because he was going to meet contractors the next morning. And there's no identification about who these individuals were, who was coming and going. There's nothing like that. All there is an identification of a general contractor, but none of their team members. Those are things that, like, it really begins to raise questions. Was Mr. Conrad, Mr. Fawcett, Mr. Williamson, were they contractors who've been working as subs on the job? Had they helped move in the dryer? All of these issues. This is why more is required.
The dryer was in a box the last time that anybody saw it prior to being in the yard, correct? So someone had to remove it from the box before it went into the yard?
Oh, there's no doubt from the record it was in a box. Whether the box was open, I don't know that anybody knows. I think that in the opening brief, I provided the images, the side-by-side of the washer machine, which had been opened and moved into place. Those are in the state's exhibit images. And the box for that particular appliance, the washer, this is page 7 of opening brief. It shows that the container for that is clearly cut. And the image on the right is the box containing the dryer. It's also clearly cut along the same cut line, which indicates to me that these items were open for inspection, which I think everybody can relate to. When you get something delivered like this, you're encouraged to open it and inspect for damage. That appears to be what happened. Now, whether the box was placed back on top of it to protect it in a construction space or whatever, who knows what happened. But they did remove the box, but I would argue there's no evidence that shows that it had been opened by these individuals at the time of the crime.
But the witness said if I'm remembering, he scared these people away somehow, so they fled when he came outside, turned his lights on, or is that right?
He activated his car alarm.
So he activated that, so they ran. Was there an opportunity, when did the police come, was there an opportunity for the defendant here to have wandered on the property and touched the dryer in the interim, or was it always under surveillance for the rest of the time?
I don't believe that the record shows that it was. Again, my understanding from the record is that there were 2 police officers who responded prior to 2 hours later. Someone else came to do the crime scene investigation. And those officers, pretty clearly from the body cam footage, there are moments in time where the crime scene was not secured, where the dryer was.
Okay.
Just give me one moment. Just continuing on with the public reputation of judicial proceedings. As stated in case law cited by the state in its memorandum of additional authorities, the failure to bring in these co-conspirators and have them testify, quote, violates some of the most basic tenets of our criminal justice, criminal jurisprudence. So I think that really, you're really checking off that third element here about fairness and integrity. And then just in conclusion, affirming this outcome would be a miscarriage of justice based on this record.
Where did the trial court judge err? What error did the trial, I mean, because sometimes somebody can be testifying to hearsay, but I would say that the trial court judge may have no duty to intervene because it's trial strategy or whatever. That may be an IAC claim. So, I understand plain error, you got to show the trial court judge erred. So at what point, where do you think they erred? When they denied the motion, denied the objection, or overruled the objection on hearsay and whatever? I mean, where did the trial court judge in that transcript mess up? Or did they have a duty to intervene when this came in? And what would you say?
I would argue that in the case of a clear rule, as this issue has been defined, the trial court did have a duty. At least, particularly once.
So every time somebody testifies in hearsay, the trial court judge should intervene just because it violates the rule, even though instead of letting them see if it's trial strategy or whatever, they always, just because something is not admissible, they always have a duty to intervene.
Well, again.
Or is this one so clear? I mean, that's what
Generally, I don't know that I can speak to that. I think there were a lot of signs here right out of the gate. I think it should have been a red flag that a clerk's office member took the stand with no personal knowledge of the case. So I think there were things that should have immediately raised some eyebrows. I would go on just to build out on that a little bit in the case that I provided for additional authority yesterday. This court has noted, quote, plain error review requires that there be settled precedent before a defendant may be granted relief. And in that case, Lane, they described that as an error of the court. So I think, again, when you have very settled precedent, something that's a clear rule, it shouldn't take that much to really trigger a reaction from the trial court.
Does that change when counsel doesn't object to these coming in?
Again, as I stated before, I would argue that an objection was made, but again, there's 3 ways for Mr. Williamson to come out here, and then I think we're leading into the last one, which is if counsel did not properly object, you have ineffective assistance of counsel, because there was no objective, reasonable basis not to do this, particularly when the state had already signaled that the alleged co-conspirators were not going to be live witnesses. So there was not going to be any, let me be explicit here, let me refer to the witness list here. Notice it's on page 16 of the record on appeal. The state noticed 6 police department witnesses, the property owner's son, and then a clerk's office staff member. I don't think, and there's any way, based off this record, that the state was going to be able to establish a conspiracy with these witnesses. Again, there was no eyewitness, and the state, they were really coming in on the back end, or the police department was coming in on the back end. But I know I'm getting close to my time here.
I was going to ask you something about this real quick, because I'm reading what the state says. This is why an IAC claim would fail. And the first reason they say in their brief is Defendant may have not objected because they may have been concerned that they objected, and then the state would have chosen to bring the two witnesses in. But were they barred from doing that because they didn't put it on the list beforehand? Could they have if you'd objected, if the trial counsel had objected, we object, would the state have had the opportunity to bring in the two witnesses?
I think that would have been difficult, particularly in a moment like that, because what the statutory notice says is what it reasonably expects to call. So I guess you'd be presuming that an objection would be made to it based off a clear rule, and you don't have these people sitting in the courtroom with you. I mean, I don't know. I disagree with that argument from the state that there was some kind of strategic choice made here. I think
Because I can see why you might allow hearsay to come in against you if the live witness was available, which would be more damning, maybe a child or whatever, but nobody really wants to call the child, so you might just let it slide.
right, and I would just back up here again. This goes to ineffectiveness, but the evidentiary record was so thin here. All you have are fingerprints on a dryer, no eyewitness, all of those other things that would typically be defined as substantial evidence to support that the fingerprint was imprinted at the time of the crime. You know, and you don't have the co-conspirators there to testify. You better be objecting to indictments and judgments, particularly when there's a clear rule against their admissibility. So, you know, again, going back.
Unless you thought there was a risk that if I object and it gets sustained, they're going to bring in the two live witnesses, and that would be worse. But I'm just trying to wrap my hand. Could they have done that when they failed to list them as possible witnesses? If they don't, then the argument that the state raises, we don't need to really consider, because that can't be trial strategy.
I think if I put myself in the trial court's judge or trial judge's shoes, and they provide this notice, and you say you didn't reasonably expect that you would need these co-conspirators to testify, you're going to just do it through a clerk's office member reading indictments and judgments, and that's going to be a clear rule that bars that admissibility, I would say no, you missed your chance. So, and we've got to keep on moving here with the trial. You made a choice, and you got to live with it.
Did the state put on their pre-trial list that they're going to call this clerk or somebody?
Yes. They specifically name her and then say, comma, clerk's office.
Okay.
You know,
You got another minute before you eat into your 5 minutes. Sorry.
yes, thank you. Let me just take one moment here. Just one final point on ineffectiveness. I would say that I could incorporate many of the things we've already discussed, but Mr. Williamson also notes that the prejudice standard for ineffective assistance of counsel is a reasonable probability of a different outcome, which is, quote, something less than that required under plain error. And that's in the Lane case that I referenced earlier in the additional authorities. And so accordingly, Mr. Williamson incorporates my prior statements regarding probable impact to establish a reasonable probability for ineffective assistance of counsel. Absent further questions, I reserve the remainder of my time.
Thank you. We hear from the state.
Thank you, Your Honor. My name's Brent Keziah. I'm an attorney with the Attorney General's Office for the last 31 years. And I was here 40 years ago as a judicial research assistant for Judge John Webb at the time, that later became Justice on the North Carolina Supreme Court. So it's good to be back. But Chief Judge Dillon and fellow associate judges, the state contends that defendant voiced repeatedly that defendant had no objection to the introduction of the indictments and judgments of fellow co-conspirators Conrad and Fawcett. Voice, as far as Conrad's concerned, co-conspirator Conrad, that they had no objection to the evidence being published to the jury. And the state contends, now I know defendant disagrees, but the state contends that defendant used the guilty pleas as part of their trial strategy. So the state contends there's no error by the trial court, and defendant hasn't shown plain error. So let's go back here, and I think Judge Chief Judge Dillon references, an indictment is merely a written accusation against the defendant and is not considered as evidence of guilt.
But it contains a statement that basically 12 members of the grand jury are satisfied that the state has evidence that these people acted in a conspiracy. That's the part that concerns me. It's a statement, not that these people pled guilty or not the judgment they're guilty of this crime, but it's a statement that says that Mr. Williamson acted with these people, and it's more than just a statement. It's basically evidence that it's a statement that there was some evidence that the state had that 12 people were satisfied. Yeah, there's enough evidence that Mr. Williamson was involved in this. I'm not so concerned with the judgment against these other two people because that doesn't mean anything. It's the fact that you had this statement, this hearsay statement in the indictment that said that the defendant in this case was involved with them. And they got to hear it. It's more than just a statement. It's basically a finding by a grand jury that Mr. Williamson was involved with it. And that to me is what's problematic, not the guilty verdicts against these other two people, because that doesn't mean anything. Because that doesn't necessarily tie Mr. Williamson to it. It's just a statement in the indictment that I'm troubled with.
Well, but I think that the indictment, once a person pleads guilty to the charge of one of the counts, it serves as an admission of all the facts alleged in the indictment. So when Conrad pled guilty to breaking and entering to this building in Durham on July 22nd, 2021, he's admitting that, at least for that count, he's admitting that indictment.
That he did it.
That he did it. Okay? So
why in the world would Mr. Williamson's counsel want the jury to hear that a grand jury had determined that his client was involved with these other two guys? Why would they? I can't for the life of me think what the. I mean, maybe they'd want to hear that these two other people were caught and convicted of it. But why would they? Why would I cannot think for the life of me why, as a lawyer, I would want the jury to hear that a grand jury determined that my client, was involved with it, or at least there's evidence that they were involved with it.
Well, the defendant, the evidence came in that someone broke into this apartment. They took the dryer outside. It's a closed dryer. Evidence came in that it's going to take more than at least two people to carry it outside. Okay? So if the defendant can say, okay, here's the Conrad has pled guilty to at least breaking and entering, and Fawcett pled guilty to attempted breaking and entering and to conspiracy, then here, jury, you have two people that have been found guilty or have been involved in this crime.
I get that, but
Yeah.
what they pled guilty to, what they heard was he pled guilty to conspiring with Mr. Williamson to do it. I mean, that's the troubling part to me. I can't feel like, I would certainly want the jury to hear that two other people are serving time for this. I mean, and I don't know why the state would offer that unless they could tie Mr. Williamson to it. But as a lawyer, I don't understand why a lawyer would ever do that, because otherwise all the state has are these fingerprints on the dryer.
Well, they have the fingerprints on the dryer, but they also have testimony that it takes two people to move. So you have a conspiracy by the fact that two people had to move it. And here the jury has in front of it two people that they can pin the crime on. Now, so they already have the conspiracy. So the defendant argues, the trial counsel for defendant at trial argued, well, these defendants have already pled guilty. So you get into another issue is, even if the defendant properly objected, once the defendant's counsel argued to the jury the guilty pleas, then they've waived that prior objection, and they've invited error. See, they don't have a right to claim plain error on appeal because they've already invited error because they argued to the jury these two guilty pleas.
Let's say if they had objected properly at trial, could the state have, could the state have gotten these two guys to come testify, or were they barred because they didn't put them on the list?
I have no
idea. You're not making an argument that had they objected, you're not, because in your brief you have in here, defendant may be concerned that the state chose to bring the two witnesses to testify, if they'd objected. So you're now saying you don't hold to that, because
No,
that's
what I'm saying
that's one of the arguments you make as trial strategy is Well, the reason they'd object is because if they had, it would have been sustained, and then we would have just brought in the two witnesses, and so the defendant didn't want these two witnesses live to appear live, so that's why they just let this slide. So my question to you was, or is, well, had they objected, could the state have called these two people, or were they barred from calling them because they didn't list them pre-trial?
I have not researched that legal issue.
So that's
And I can't cite the case that says that, but I do know that there's case law out there that says that the court, that it's always in the discretion of the trial judge to allow additional witnesses. Now, of course, usually that's in case of rebuttal, you know, if they bring out and the trial judge allows the state to call additional witnesses. But I don't want to say that I know there's case law out there that would give them the opportunity to bring those witnesses. So I don't want to state on behalf of the
okay.
state.
That's fair.
Do you concede error but not plain error?
No, I don't concede error because I think the distinction here is that this is the indictments, the guilty pleas are relevant evidence.
Of what?
It's relevant evidence of a conspiracy, okay? And in U.S. versus Toner, now I'm having to go to a persuasive authority in the Third Circuit, 173 Federal 2D 140, they stated, from a common sense point of view, a plea of guilty by an alleged fellow conspirator is highly relevant upon the question of guilt of another alleged co-conspirator. Okay? So, at least the Third Circuit is saying it's relevant that this person, part of a conspiracy, pled guilty. Okay? But now, it's inadmissible because of the clear rule. Okay? But a defendant can waive the clear rule. Okay? And that's what we're contending happened here.
Did defendant request a limiting instruction?
No.
What's that last part of the defendant can waive a what rule?
The state's position is defendant can waive the clear rule. The rule that says that co-conspirators' guilty pleas cannot be admitted because it's not competent evidence. Okay? So, as far as Fawcett is concerned, he's a co-conspirator that pled guilty to conspiracy. Okay, I think as far as using this U.S. Toner case, that case established that conspiracy theory makes it relevant. Okay, so even though it's inadmissible because of the clear rule, the defendant can say, well, I want to waive the clear rule.
It's admissible, and if the person had come in and said, yeah, we conspired and stole this thing, then that would be competent evidence. That would be admissible because it's not hearsay, but the guilty plea itself. I'm just trying to understand. So, okay, so they waived it. So why they waived it, the lawyer made that decision. Why? I'm just like, because I can't understand what a trial strategy, because if I objected, they wouldn't hear any of this stuff. All they would hear is there were my client's fingerprints were on the dryer. They wouldn't hear anything about these other two guys unless they came to testify.
No, well, the way the evidence came in, the state brought in a fingerprint expert, and the fingerprint expert testified of the fingerprints of both of the defendant on being on the GE clothes dryer, and they admitted into evidence the fingerprints of both Conrad and Fawcett.
And there were other fingerprints that weren't recognized. So we don't know what three people did it until the indictment came in. So the jury would have had no clue. This is where I'm hung up. I can't understand the trial strategy, because if there is no rational reason for a lawyer to allow it in, then is there a reasonable probability the jury, at least one, might have had reasonable doubt? Because all I hear is there's 5 sets of fingerprints on this thing, and there would have been nothing before the court that would have tied Mr. Williamson to these two people, except the indictment they got to hear about. Because if I'm a juror, I don't know which 3 people moved it. Or
Do the 3 sets of fingerprints tie Mr. Williamson to Conrad and Fawcett?
It's the fingerprints were found at the crime scene, and the latent prints were done after the crime was reported to the police. But You know, there's no eyewitness that saw the defendants that the people putting fingerprints on the thing.
So what is all of the evidence that you had of conspiracy? The indictments and the fingerprints. Is there anything I'm missing?
Well, the conspiracy is it takes two people to move the clothes dryer.
Okay.
Now, the victim saw 3 people running off. Okay, he heard someone break in. He heard voices going on. So that's evidence of a conspiracy because he heard multiple voices. And then he saw 3 people running off.
And there were 4 or 5 different types of fingerprints that were found. How many? 5?
There was Conrad, Fawcett, and defendants, and then there was another fingerprint on the clothes dryer that was not identified who that was.
So 3 people ran off, but there were 4 sets of fingerprints on there. So
On the clothes
the only
dryer.
thing that made it certain that, so I'm a juror, and I just hear there's 4 sets of fingerprints and 3 people ran off. I don't know who the 3 people are. I have reasonable doubt that it was a defendant until I hear this indictment that came in that said that these other 2 guys said, oh yeah, it was him that was with us. I mean,
There was evidence of whose fingerprints they were some of the fingerprints.
They found the state had already brought in evidence that the fingerprints were of Conrad, Fawcett, and the defendant. Now,
and a 4th person.
And a 4th person. And that unidentified 4th
And
person.
only 3 people, and the evidence also was only 3 people were there.
The person saw 3 people running off and heard voices.
So I'm a juror, and I don't know which 3 it was. It might have been Williamson, but I'm not sure until I hear this other evidence. I mean, so I'm just trying to figure, is there a reasonable probability that at least one juror would have had a reasonable doubt? Because I don't know which 3 it was. I mean, the state hasn't told me that he was one of those 3 people. It could have been that 4th person that I don't know who that person is. Until I hear that indictment evidence, when I hear that indictment that says so-and-so has been indicted by being with the defendant, whatever, then I'm like, okay, it had to be him. I mean, which shouldn't have come in unless the other 2 guys would have come to testify. That's where I'm stuck on the IAC claim.
Let me say this then, because the defendant's trial strategy, they see that the Conrad and Fawcett are not on the jury list. They see this clerk is listed. Now, I haven't talked to the defendant's attorney. She may assume this is the way they're going to bring this evidence in. May or may not, I don't know that.
Does the defendant have any duty to object before trial? Hey, that won't be admissible, or can they just wait until you try to see what
Well, I think you have to wait until the evidence comes in.
Okay, so there's the defendant has no duty to tip their hand and say, we're going to object to that, to let the state should have put the other 2 guys on the list. They didn't do it, so they're stuck with this.
Yeah.
And so the defendant has the right to object. So why wouldn't you object? Then they don't have anything.
Well, because if here, you got testimony of these 3 fingerprints.
4.
Of 3 people, 4 fingerprints.
And 3 people running off.
That's right.
That's
And
all you got.
You've got a crime committed, so you're going to argue to the jury that it's these 2 people over here, and you're hoping that your strategy was. Now, I'm speculating here, okay, because we don't have defendant's trial attorney here, but maybe she says, I'm going to put my client on the stand, okay? Now, when the second day, now you understand that what's happened here is this defendant chose not to attend the last 2 days of his trial, okay? So here the strategy is we're going to put in front of the jury someone to pin the crime on. We're going to allow this evidence to come in, and then my client's going to get on the stand and say, my fingerprints were put on there because I'm a subcontractor and I was moving the clothes dryer. But I'm not part of this other crime. And so now you have to get past the point that the defendant's got quite a lengthy criminal record, so I don't know if that's a good argument or not. But I'll throw something out there to you, Judge Dillon, about the possibility that maybe that was their trial strategy, that they knew that the jurors would want someone to pin the crime on. They got 2 people that's already pinned the crime on, and they're going to let my client off the hook because he's going to state, and that was pretty much their argument to the jury in closing argument is you got 2 people, my client, there's no testimony that pits him together with those other 2 people, so that should be enough.
Well, the defendant has to show a reasonable probability of a different verdict, correct?
That's right.
How high is that bar?
Well, that's a high bar. Now, if you find out that the defendant objected, okay, this is a whole different playing game.
Well, of course, but I mean, under plain error review,
That's
how
right.
high is that bar?
That's right. It's a high bar debate. But if the defendant objected, then we go from plain error to the state, because it's a constitutional violation. I think it's GS 1443-C or something. The burden shifts to the state to prove.
Are you conceding that defendant's objection on the grounds of relevancy and hearsay is also an objection, or constituted an objection on constitutional grounds?
No.
Or confrontation clause and due process?
No, I say the defendant, when
So how are you getting to harmless error then?
I'm getting to no error.
No, I mean, but you were saying the state has to prove.
Huh?
You were saying the state has to prove harmless error.
I'm saying if this court finds the defendant objected
On constitutional grounds.
on constitutional grounds, then the burden shifts to the state to prove, beyond reasonable doubt that no harmless error.
But if they objected on other grounds, like it was just hearsay, it would just be that the defendant still has a burden to show there's a reasonable possibility of a different verdict.
Yeah, I mean,
No, possibility or probability?
The possibility if it's objected to. If it's plain error, that the jury probably would have come to a different result. But then you have IAC, which is not that high. IAC is just if we don't think that the attorney had any reasonable ground, it was just there's no reason why he didn't object, and he or she should have objected. Then it's like, is there a reasonable probability, which is less than 50%? It's not as high as plain error. Is there a reasonable probability that at least one juror would have at least had reasonable doubt that this guy was tied in with this crime? Because you just said, well, there was no testimony that tied him with these two other people. Yes, there was. It was there's evidence. It was in the indictment that got in. The indictment alleges that he worked with these other two people. I don't care about the fact that these people pled guilty because the jury knew three people did it. That wouldn't have swayed me one way because I still wouldn't know which of the other two, was it this guy or the unknown fingerprint, until I read that indictment. Until that, as a juror, I get to see the indictment that says, oh, it was this guy, because that's what the grand jury found.
Well,
that's my concern. I don't know why the trial lawyer let the jury hear what the grand jury had found that my guy was guilty, or had worked with these two other people who pled guilty. That's what I don't know what the trial strategy is. I'm not saying about the guilty pleas themselves, but the fact that they got to hear, why would I let the jury hear that a grand jury found that my guy worked with these two other guys who pled guilty to be part of this? I can't think of a reason why anybody would have a law license and have that as a trial strategy. I can see it just being a mistake. They should object. They just messed up. I mean, because we all make mistakes, but why that would be a reasonable, I can't, and if I don't think that, then it comes to me, is there a reasonable probability the jury would have come to, unless it was, like you were saying, that the state would have had the opportunity to call these two people. In the trial strategy, let them hear this hearsay, but you're basically, so I guess I need to figure out, could the state have called these two people at this late stage if they hadn't identified them before that they could have?
Now, I have no reason. I mean, I just don't understand the state's strategy in calculating.
I know y'all are coming here later. I get that. I mean, it's not.
Now.
Do you have an argument against dismissing without prejudice to filing of an MAR?
I'm sorry?
Do you have a...
No, I think that this is a good case if you're alleging ineffective assistance of counsel for it to come back for a hearing as to whether the attorney was competent or not. I mean, then,
if we have questions as to whether or not counsel had whether this is part of their trial strategy, it seems perhaps the best way to find that out would be to ask the attorney. But I was wondering what you had to say about that.
I'd say 100% that's the way to handle it. In defendant's reply brief, they mentioned the word, well, maybe the attorney was sandbagged. The defendant's trial counsel was sandbagged by the evidence that the state did not put the two witnesses on there. And so when the evidence came in, they were sandbagged. My argument to that is I don't think that's evidence of sandbagging. I think evidence of sandbagging is if Durham District Attorney's Office had put the two names on it with no intentions to call them, and then called the clerk and then closed their case. So that's where I think that it's not sandbagging. And even if you go to whether the defense counsel was sandbagged, then aren't you saying that maybe she's not ineffective? Because if she was surprised by this, then you should at least consider the fact of how a reasonable attorney would handle if they got sandbagged in the situation.
If I was a defense lawyer and I saw the state saying that we're going to call this clerk, and I have no duty to object to that pre-trial, and the state's failure of putting these two other guys on that list would foreclose their ability to call them, I wouldn't say anything until trial and then object to it, but they didn't object to it. I would have objected to it, and it would have been sustained, and the state's got nothing. All they have are the fingerprints. There's nothing to tie, because I just, for the life of me, still don't understand, unless the state was going to have the opportunity to call these two guys and say, yeah, he was our third guy, why you would let the jury hear that a grand jury had made that finding? There's just no trial.
Unless they had already talked to the defendant's counsel, or they were just gambling. You know, I don't know the answer to that question. You know, I think that's why you have a good hearing. But here, you not only have a situation where, you know, there's 23 published cases on clear rule, okay? Most of the cases where defendant doesn't object is where, when they fail to object, is the evidence comes in and they just say they remain silent. But here you have defense counsel not only just remaining silent, she verbally said no objection. She verbally said, yes, I have no problems with being published to the jury. She mentioned to the trial judge in this little brief argument 3 times that she had no objection. Now, I don't know what else.
No, I'm not arguing with you. Maybe she did waive it, but but is that what makes it ineffective? Is there's no trial strategies in the waiver. I'm not saying the trial court judge even committed error if she waives it. So it's not even a plain error question at this point. It's just whether or not she committed ineffective assistance of counsel. And I'm just in my mind, unless the state could have called these 2 other guys that could have hooked Mr. Williamson to the crime, why in the world would I want to hear the jury hear anything that connected my client as being the third party when I could create reasonable doubt by just saying, look, there are 2 sets of fingerprints besides these 2. You don't know which one it is because there's nothing that says it was my guy and not the other person. I mean, there's nothing, there's really nothing. That's what why would you want them to hear anything that tied my guy to these other 2 guys?
Well, unless it was their strategy to pin those crimes on it because the defense didn't want to gamble that the jury may still, this goes to the weight. So the weight of the evidence, was there enough weight to survive a motion to dismiss? And I say yes. So the jury may still come back, and I agree, one juror may say, well, I don't see all the connections, but there's a chance that 12 jurors would say that.
But on a motion to dismiss, the trial court considers incompetent as well as competent evidence. So isn't that much different than what?
Oh, yes. And that's why the motion to dismiss, you know, the judge can consider this clear rule evidence coming in. Now, I want to say, though, I want to point out the distinction here, because when the defense attorney did say argued relevancy, okay, she first, the evidence came in saying no objection. Then she did argue relevancy. Now, of course, I'm arguing that it's relevant, but not unadmissible, but I do have a question. When the indictment came in on Conrad, there was 2 counts in there that defendant didn't plead guilty to. So is that relevant evidence? I have concerns about that. So when defendant's attorney said relevancy, then the next statement, the judge interrupted, then the next statement she made was, well, I don't have any objection coming in to being published to the jury, but I don't want it read to the jury. Okay, but I do have concerns that the other counts on that indictment, I have concerns whether that's relevant evidence. Now, there's a U.S. versus Griffin, 11th Circuit. I'm having to go outside because there's just no case law in North Carolina, but 778 Federal 2D 707. In that case, defendant appealed a conviction of conspiracy and mail fraud. Okay, at trial there was testimony that the co-conspirator had been solicited by a defendant to burn down defendant's house. The co-conspirator did not testify. The court, here, the trial court, the district court federal judge, advised the jury that the co-conspirator had been indicted and adjudicated guilty of arson. The court even read the non-testifying co-conspirator's indictment to the jury. The 11th Circuit stated that the co-conspirator's guilty plea for arson was relevant since it's a conviction stemming from the same facts as in defendant's case. So I think we can get past this one point. Now, I do want to point out, though, that there was evidence submitted on the fingerprint evidence, cards for the defendant, fingerprint cards, and Conrad's fingerprint cards, and Fawcett's fingerprint cards were admitted. And they had charges on there that had nothing to do with any of this. So I have concerns about that. The defendant has not raised them on appeal, so I deemed them abandoned, but, you know, when you're considering the case, I do have concerns. So I guess I want to end here. The state contends that the trial court committed no error. But if the trial court did commit error, it is not prejudicial. And the defendant has shown no plain error. And I've just mentioned some issues with this case where maybe the trial court should have said something. But appellate courts long ago rejected the notion that reversal is necessary for any error committed by a trial court. Our judicial system is populated by fallible human beings, and some error is virtually certain to creep into even the most carefully tried case. Now, I'm going to quote from a Georgia Supreme Court case in 1891. 87 Georgia 584, Broome versus Davis. And the court said, "Indeed, fallibility is inherent in all courts except the court of last resort." So, with that, I'll say the state requests that you uphold the jury verdict. Thank you.
Thank you. Got 5 minutes for a vote. 5 minutes, 15 seconds.
Yes, this will be very short. I sense that this is settling out of the ineffective assistance of counsel issue and the question about dismissing for an MAR. I don't think that's necessary. I believe that the error is apparent from the face of the record. If the court chooses to go that route, I would just encourage the court to consider, though, the possibility that, again, with this context, where if the blame is being put at the defendant's counsel of why would you allow this to happen, I don't know why the state would have attempted to try this. Getting in these indictments and judgments through a clerk's office staff member, and I also don't understand why the trial judge did not pick up on this, particularly in light of the additional authorities provided by the state, where they pick up on it so quickly. And to be honest, it seems like really there's a real possibility that none of these three stakeholders knew the clear rule, and that was the result here, which is that my client got convicted off a very thin evidentiary record. I'm happy to respond to any questions from the court. Otherwise, Mr. Williamson respectfully requests that his conviction be reversed.
What did the clerk say that tied your client to this crime? Not the guilty verdicts or the judgments. It would have been just simply the indictment? Or am I wrong about that? Was there anything else that, because the indictment said your guy was part of it. Is there anything else that was, because the clear rule is just it was somebody else convicted of it. Correct.
So I was making some notes of this while we were going over this. Mr. Conrad pled guilty to breaking and entering and identity theft, which was a separate crime.
That doesn't tie Mr. Williamson.
And then Mr. Fawcett, and I think this is a curiosity, was convicted of attempted breaking and entering and conspiracy. So
But I still don't know, as a juror, who he conspired with. I know there's two other people, and one of them did it, either your client or this unknown person. I don't know until I hear that indictment. When I hear that indictment, that's the damning part to me. So
I would agree with you because the judgment doesn't reference Mr. Williamson. So I guess the closest connection you'd have to be able to make it would be the offense date of the judgment.
Did the defendant's counsel have the opportunity to ask the clerk questions prior to not objecting to these exhibits being admitted?
An opportunity to, let me just look again. No, it was just, again, the state moved to admit the documents, and then the trial counsel immediately said, no objection, and then the court responded, all right, that's allowed.
But
and that's kind of the extent.
Counsel could have said, Your Honor, may I ordaire this witness, something to that effect prior?
I assume that's possible. I'll go back to some comments I've made before about the foundation. I think you have pretty good indication about the reliability of these indictments and the judgments, but there's nothing really about the relevancy to this case. Again, it's just Exhibit 11 and 12, indictment and judgment, bears the seal of the county, and then it's self-authenticating, no objection, admitted. That's kind of the extent of the exchange. So, well, if there are no further questions, I appreciate your time.
thank you, guys. Appreciate it. Thank you for your argument. We will take it under advisement.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
Good job. Thank you.
Judge Dillon really was homing in on that.
Right, no, it's a curious case.
It's a curious case. I don't know what the state was, I think it was just gambling to just see if we can get past it. But I kind of wonder if you're correct, whether they just had, all three of them just had no, and I looked at when they admitted the bar.